We got a big development in the Houston taco shop shooting case. The grand jury says no indictment here. We got a full breakdown for you. Stay tuned. This is attorney Andy Marcantel and attorney Marc J. Victor. We're the partners of the Attorneys for Freedom Law Firm here today to talk about the end of a story of a hero. Some people called him a vigilante, but the grand jury agrees this guy looks more like a hero. How you doing today, Marc?
Good, man. I'm inclined to call this guy a hero. I don't know that he acted perfectly here. I love doing these kinds of videos. Of all the kinds of videos we do, these are my favorite because this is what gets us to what we love the most, which is being lawyers.
Yeah, absolutely. Just
picking it apart.
Analysis, pure raw analysis of a shooting.
The hard part about doing these kinds of videos, we could talk about this one for 3 hours.
Yeah, it's absolutely true. But we're also kind of playing Monday morning quarterback right now because we know the end of the tale, right?
That's right.
This has been going on for about a year now.
Yep.
The incident occurred in January of 2023, and we are making this video in January of 2024. And the big news here is that the case went to a grand jury, was presented to a grand jury, and the grand jury returned a no true bill. So essentially, no crime, no indictment, nothing's going to be charged. And the shooter, who still, by the way, at this point has not been identified, is not going to be charged with a crime. Good end to the story.
Yeah, I think so. And so what, you want to watch the video first? And
yeah, why don't we start by checking it
okay.
out? Yeah, here we go. We got some festive Mexican music playing, very fitting for a taco shop.
I was just going to say I love the music. It makes me think of a scene out of Breaking Bad or something.
And we have an armed robbery in progress. People throwing money, throwing their valuables, pointing the gun everywhere.
All over the place, reckless.
And here we go. Two volleys of 4 shots and a final shot. And a little bit of community service here.
Look at that, yeah. Come get your money.
Come get your money, lays it all out on the table. Little frustration when he finds out it's a fake weapon. And there he goes.
Taking off. Where do you want to begin?
All right. Well, I think it's really important to break this down in terms of the 3 different volleys, right?
Yeah.
Because there's definitely different levels of analysis here in terms of the imminency of the threat and the posture of the shooter, the posture of the armed robber. So I think it's important to kind of start from that 30,000-foot view, is that this was an active scenario where the legal analysis was kind of changing rapidly.
Yeah, I mean, I think the place to start is good for this guy. I'm glad he's carrying his firearm because stuff like this happens, right? Bad guys, and this guy's clearly a bad guy. I mean, you don't know it at the time who he is, but, turns out this guy's got a prior armed robbery. Somebody died in that.
Right.
All that's irrelevant to the analysis because as far as we know, the shooter in this case isn't aware of that, right? If he is aware of that, then it becomes relevant to the analysis, but he's not aware of that. But it's a good thing that this guy is carrying a firearm. We don't know how this would have ended. We don't know that this just would have been a robbery. He may have executed every person in there if he wanted to. He could have killed one person. So this guy may very well have saved lives because of the fact that he was armed.
Yeah, also the fact that the gun turned out to be a fake is also completely irrelevant in the legal analysis. And this part's confusing to some people who don't understand different states' reasonable mistake of fact statutes. And what that basically means is if a reasonable person would have believed that this was a real firearm and an imminent threat, as the armed robber no doubt was intending it to be presented as, then you can treat it as if it's actually that threat, and the law is not going to punish you if you just turned out to be wrong.
Yeah, if this thing's a green water squirt gun or something, and no reasonable person looks at it and thinks it's a real firearm, that's a different outcome, right? But this guy, as best we can tell, subjectively believes. In fact, if you see the video, when he finds out it's a fake gun, he throws it against the wall. Okay, he's upset. This is good evidence of what he believed at the time that this thing was going down. So he subjectively believed it was a real firearm, and, very importantly, an objective, reasonable person, right? Because it's not just about what you subjectively believe. It's also about the imaginary, hypothetical, reasonable person in such a circumstance. What would a reasonable person believe? And I think it's pretty clear here that a reasonable person would believe that this was a real firearm. So, like you say, the fact that it's fake doesn't matter. There's no reason for this guy to get upset and throw the firearm against the wall.
Yeah, just like this guy's criminal past doesn't matter. It's important to parse these things out, right? Because when people get the whole story, they might have an emotional response to it. They might say, "Good, I'm glad the guy's dead." That's not our role here. Our role here is as lawyers, and we look at things that are actually relevant to the legal analysis of whether this was a good shoot.
Yeah, and you know what? It looks like the guy who was the shooter, I'll say, well, let's call him the good guy.
We're showing our bias a little bit, but I think that's appropriate.
Well, I mean, look, one guy's coming in to rob the place and put everybody...
Oh, you mean the bad guy, yeah.
Yeah, that's the bad guy. And the guy that's trying to prevent that guy from robbing the place, that's the good guy. I feel pretty comfortable in saying that. Now, whether the good guy acted entirely within the law is a different question. That's what we're here to talk about. But it's clear to me that the good guy had some training. Right? First of all, he's carrying a firearm. Second, he's pretty careful. He's thinking about when he's going to pull it out. He does pull it out. He's got two hands on the firearm. He's not going all cowboy style. I'm not sure exactly why it takes him 4 shots to hit this guy. It seems like he didn't hit the guy on the first or maybe second shot, but that's fine. I think those first 4 shots are very clearly good shots.
No doubt. Under multiple different theories of defense, by the way.
Yeah.
Because as with every jurisdiction in the United States, in addition to a self-defense statute, there are defense of third-person statute, which basically means you get to use the same amount of force that person who's threatened would have been able to use had they had a gun.
Yeah.
So, I mean, this guy's pointing his gun all around.
It doesn't
the place.
matter that he shoots him in the back. You know, some people are so sort of enamored by whether the shot is in the front or the back. It could be bad, even if it's in the front. It could be good if it's in the back. And this is a good example, especially for those first 4, of a time when you can shoot somebody in the back and still be legally justified. So I think that most reasonable people who understand self-defense law are going to say those first 4 shots, we feel pretty comfortable in saying this is a good shoot.
And if that was the end of the analysis, this would be a very, very easy open and shut case. This is the type of case that we talk about generally when we say, when like an obviously good shoot comes into the firm, it's probably not going to be charged. It probably won't even end up, as this case did, in front of a grand jury with the possibility of charges. That would probably just be the end of the analysis. Yeah. But then some more shots come, right?
Yeah, then you get the second 4. The second 4 are definitely more problematic. If those second 4 happen in New York or California or Maryland or New Jersey or one of those states, definitely going to be charges here.
I agree. And in fact, to evidence that, there were outcries from all over the country, from jurisdictions just like that were saying this guy's a vigilante, we need to prosecute the guy, poor criminal guy, yes, it's true, he was down on his luck and wanted some money, but that didn't justify him dying, and this guy shot him in the back, and after the first 4 shots at least, he was neutralized, and then the rest was just an execution.
Yeah.
And so, yeah, definitely, if the jurisdiction was different, we probably would have seen a different outcome.
Yeah, and I think it's important to note that the law is not really that different in those states, right? So you're dealing with pretty much the same law. I mean, there are some small nuances here and there, but for the most part, you can make a statement about American legal jurisprudence in regards to self-defense law. So the law's not that different. What's different? What's different is what the people in the local community who are going to be randomly selected to be on the jury, what are they going to think is reasonable? And I think people a lot of times lose sight over the fact that it's not what you think is reasonable. It's not what I think is reasonable. It's not what your pals who also like to keep and bear arms think is reasonable. reasonable. It's what are the randomly selected group of people in that particular jurisdiction, what are they going to think is reasonable? And I'm sure that the grand jury in this case that chose not to indict, that's what you're dealing with. You're dealing with a randomly selected group of people from Texas who are looking at this case and say, wait a second, we can tell who the good guy is here. You're not held to a standard of perfection. You're held to a standard of reasonableness. And look, we always talk about these with two hats, right? Hat number one, what's the analysis under self-defense law?
Cold, calculated legal analysis, as I like to call it.
And then there's the other hat, right? The hat we like the best, which is how would we defend this case?
That's right.
And that's a different lens. And so we got to be clear about that sometimes.
Well, real quick, just to jump in there on that, because you actually skipped one of the other buffer zones that goes into the analysis on deciding whether somebody is charged, which is what the prosecutor wants to do with the case in the first place. There's an analysis before you get to that grand jury, that randomly selected group of people from the jurisdiction, which is the prosecutor doesn't have to take it to the grand jury.
That's right.
And oftentimes the prosecutor independently decides, no, I can tell who the good guy and the bad guy here is. And so that's why when you have a jurisdiction with, what some people might call maybe a woke prosecutor or somebody who's not as gun friendly, they're going to be a lot more adamant, one, to make that determination to bring it to a grand jury in the first place, but it's also going to change their presentation to the grand jury. It's going to change the manner in which they present the evidence, and it shouldn't, but in the real world, in the practical analysis, it does.
We could go off on a tangent and just talk about grand juries. Like, oh, you thought you got notice of this thing? You thought you got to go and present some evidence, or your lawyer was going to be there? No. This is a one-sided presentation by the prosecutor and usually one police officer on the stand and the members of the grand jury and a court reporter. You're not even dealing with a judge here. Right. So, it's hard to imagine.
Rules of evidence don't apply.
Right.
They can provide whatever they want. And oftentimes they tend to hide the ball on what we might call clearly exculpatory information. That's stuff that if we, the defense attorneys, were there, stuff we would want the grand jury to hear.
This is why we get the transcripts and challenge what happened at the grand jury. And on several occasions, we've been successful, and we've had cases thrown out on this point. But that's a segue here. So those 4 shots.
The second set of 4 shots.
The second set of 4 shots. So the part that's so problematic about this is that the bad guy goes down and you can see the gun go right out of his hand.
Yeah.
Of course, this raises issues, right? Just because I can see that on the video and you can see that and we can all see that, what did the good guy see in the heat of the moment, under the stress? Did he see that? This is one of the reasons you keep your big mouth shut. Right? Because you can imagine the police show up and they say what happened, and then he says, yeah, this happened, that happened, I saw the gun leave his hand after the first 4 shots. And I'm going, that's going to be one of the bad facts. But if you keep your mouth shut, and then later on you have this argument, at least, if this is what the client says in the private attorney-client meeting, I don't think I saw that firearm. I thought the guy still had it. I was under the stress or this or that. That could make a huge difference in a case like this.
Remembering here, hearkening back to what we were just talking about, reasonable mistake of fact applies as to all aspects of the defense. So that includes even if he had literally dropped the gun, if we can make the argument that in the heat of the moment, maybe the guy was hunched over, maybe it looked like he had something in his hand, the fact that he didn't actually have a real firearm is irrelevant if a reasonable person could have believed he had a firearm in his hand.
Yeah, and to be fair, we're real defense attorneys, right? So this guy, he might not say anything publicly, he might not testify, and we can still make the argument, what is the evidence that the guy saw, that our client saw that firearm sort of slipped out of his hands? How do you know? Where's the proof? And, we might know that, yeah, maybe he did see it, but they still got to prove it, and they haven't proven that fact. So this is, again, why we always say, keep your mouth shut. Now, I noticed this guy at some point was cooperating. So people might say, well, look, Mark, he cooperated. Yes, he did. But after he got a lawyer, after the lawyer had an opportunity to review this video.
Looked at everything very carefully.
Sit down and say, hey, man, what did you see here? Taste, touch, smell. What did you believe at the time? And also problematic here is the fact that he leaves the scene. Because, you might think by itself this isn't so terrible, but prosecutors often will argue what they call consciousness of guilt.
Right.
they'll say, Judge, we want to bring the fact that this guy fled the scene and argue to the jury that the reason he fled is because he is aware himself in his own mind that he broke the law, and we want to present that to the jury. So, it's not a good idea to flee the scene because, if you do that, they get this sometimes a consciousness of guilt instruction, and that could be problematic, right? Why did you flee the scene? These are the kinds of things you think about. This is why you call your lawyer as quickly as possible because, we go through these kinds of cases and we know what the issues are, so we can advise people right then and there at the scene what to do. And we would have said, look, the fact that it's a fake gun, not a problem. The fact that you shot him in the back, not a problem. The fact that the gun was in his hand, did you say anything to anybody? Okay, keep your mouth shut. Maybe not a problem. So I think this case here is one example why it can be a good idea just to keep your mouth shut. Because again, if there's something you want to tell them, we can always tell them later, right? And it appears that this guy did exactly that. He retained a lawyer.
Imagine if this guy had followed the advice that some companies give and some groups give to say, I was in fear for my life. He stuck around and made the statement, I was in fear for my life. He loses that third-party defense.
Yeah, right.
He loses the interesting Texas defensive property
Yes.
statute. Basically, he just forecloses his future defense attorney.
Yeah, you
from
didn't fire. You didn't fire
all
to
of these
protect
different
these
things.
other people who were around. You shot the guy in the back. I mean, so why create these issues?
Yeah.
Keep your mouth shut. Again,
So just to reiterate, that second round of 4 shots is problematic because arguably at that point the threat was neutralized by the first 4 shots, and it looks like the gun kind of flops over and is no longer in the control of the armed robber. Okay, well, some people ask the question, how does he know he doesn't have another gun at that point? He's already demonstrated that he's violent, and he's preying on these people, and he's waving it around. A good question, something a defense attorney would raise for sure, and this guy's already shown that he has a proclivity to be violent, but I don't see anything in the video that looks like it could be another weapon. But once again, if you keep your your mouth shut, then there might be an argument. We might be able to find something that looks like an object, or his hands are hidden from view, or a motion that he made with his body as he was falling down looked like he was going for his pocket. There's so many different things.
Or he says, I heard somebody say, he's got a gun or he's got a knife.
Right,
Who knows what he's going to say? Who knows what's going on in his head? Keep your mouth shut. Okay, I think we've made that point. But yeah, I think that the second volley of 4 rounds is obviously problematic, right? And I think this thing's outside of Texas, maybe outside of Arizona. I think this probably gets charged in Arizona, frankly.
Maybe, yeah. This is definitely in the realm of questionable shoot, right? If we break it down to obviously good shoot, questionable shoot, and obviously bad shoot, this is definitely in the realm of questionable shoot for those reasons. Then there's the last one. The last shot, which is actually the 9th round that is discharged here. This one's problematic.
This one's a big problem, right? Because now there's no question about the fact. I mean, the good guy's now picked up the firearm. He's now 100% sure this guy has been disarmed, at least of that firearm, and then he shoots another round. The first thing that pops into my head when I see that is this guy's already dead. To the state, prove that the guy wasn't already dead. Okay, we'll take the, desecrating a corpse or something like that type of a felony, because that's not going to put you away for the rest of your life. And then you get into questions about legal death. And I've dealt with these questions before in first-degree murder cases. And, in Texas, I took a quick look. Texas says death is defined as an irreversible cessation of respiratory and circulatory functions, which means, the blood isn't pumping anymore. That's a different definition than we use in Arizona, which is brain dead. Well, if he was shot in the head from any of those first 8 rounds, you could make a really good argument. The guy's already dead. And so that 9th shot's irrelevant. It's just defacing a corpse. Yes, he made a mistake, but it's a causation problem. That mistake, that last shot isn't what caused the death. Now, if it hastens the death, if the guy wasn't dead yet and it caused him to be dead 1 second sooner, sorry, that doesn't help you at all. But if the
Right.
guy's already dead, so this becomes a question now, a battle of the medical examiners.
Yeah, we put our forensics and medical experts up, and they talk about what causes death and definitions of death, and they put theirs up. And yeah, this could become quickly a sticky kind of expert battle. But, a creative prosecutor might point out the pretty obvious fact that there'd be no point in discharging that ninth and final round unless he actually thought that he was still alive, and so try to make it something like an attempted homicide, an attempted murder. He's trying to kill the guy, and even with a deceased victim, could still meet the elements of that particular crime.
Yeah, and it's hard to know, right? Because we haven't got a chance to talk to the good guy. We don't even know his name. But it'd be fun to get him in the office and say, what were you thinking? Right. Why did you fire that ninth round? Did you see a move? Did you see something? Did you hear something? But it's really hard to justify that ninth one, right? And although I would say, like we do in all cases, we haven't even talked to the guy, we'd keep an open mind to see what's defensible. I'm sure if this guy gets charged, just as a sort of an aside, if this guy gets charged with murder and he's an AOR client, there is no question we're going to defend this guy.
No question.
Yeah, no
We'd be
question.
champing at the bit to defend this guy. But ultimately, the things that made that last shot problematic are irrelevant. The grand jury, in our opinion, did the absolute right thing here. They took a look at this. And that's one of the things about the grand jury process and the jury process had this eventually gone to trial, is that, we lawyers can pontificate all day long. We can talk about the statutes. We can talk about imminency. And that's an important job when we're arguing these cases. But at the end of the day, it's up to the jury. And this grand jury hadn't even heard anything other than the presentation of what the prosecutor put forward.
Yeah, and also, that ninth shot, by the way, could have just been an accident. He could have said, I'm just holding my gun. Oops, I pulled the trigger involuntary or something like that. That's another thing that, maybe you learn when you meet with the client. But, there's a term in the law called rough justice. And we don't get it perfect. This one kind of fits in the rough justice box, right? When I step back and I look at the whole thing. Look, if you don't want to be shot and killed, don't commit a robbery. Don't come in with a fake gun or a real gun. Don't do these kinds of things, and you will substantially decrease your chances of being shot and killed, right? But this is the type of guy we're dealing with here, and he took the risk, and the kind of thing that happens in these kinds of cases happened. Now, even if the last shots are bad, you kind of have some, I think, compassion for the good guy here, right? Because police officers who get a lot of training make mistakes like this all the time. And people who are highly trained, remember there was that video with the guy from the ATF who's coming into the classroom years and years ago. He's there to present gun safety to students in the classroom. And he pulls out his firearm and boom, a round goes off. It gets discharged right there in the classroom. I mean, things happen. And again, I think you're not held to a standard of perfect justice, right? And even if he didn't act perfectly, what you try to do as a defense attorney here is you try to get jury nullification without saying, hey, you got a right to come back not guilty, even if you think that the prosecutor has met all elements of the criminal charge.
Yeah, just to be clear, we are not allowed to argue that at all.
Talk about that. It's outrageous.
That is kind of outrageous, isn't it? That there are rules in every state in the United States of America that says we can't advise the jury that the law is wrong, and maybe they should use their power as jurors to nullify and say, you know what, we don't agree with this. We think this is an unjust law.
Yeah, it's a really murky area, right? Because everybody recognizes that the jury has the power to nullify the law, right? They can say, look, and again, it's not nullify the law generally. It's nullify the law as applied to this case.
Right.
What they're really saying is, yes, we understand that this is the law, but, on these facts, under these circumstances, we just refuse to come back with a guilty. Now, they have this authority. But instead of being able to tell them that, like, we can't stand up in front of the jury and say, look, ladies and gentlemen, even if you think the prosecutor proved every element of the charge, you can still come back with a not guilty and give this guy a break. Because at the end of the day, even though he wasn't perfect, he's the good guy. And do we really want to put the good guy through a prosecution for first-degree murder? The answer is no. We can't argue that.
Right.
No, so we can nibble around the edges of that and say, hey, he's not held to a standard of perfection. It's a standard of reasonableness. reasonableness, and he wasn't perfect. He acted reasonable under the circumstances. This is a bad guy. He doesn't know about this, that, and the next thing. And
this could very well have been the analysis in the Alan Coley case. When you and I saw that video the first time, he didn't act perfectly, very arguably. And the jury took a look at it and said, you know what? We don't think he acted perfectly, maybe, but we think he acted reasonably with regard to that self-defense incident. So
at the end of the day, this one has a happy ending because you don't want to see this guy go through a prosecution. I wish he hadn't fled the scene.
Well, some people did want to see him go through a prosecution.
Yeah.
Many people from many different jurisdictions. It was shocking to me, some of the coverage of this story, sympathizing with the career criminal who was sticking guns in people's faces, and we have a guy who's trying to protect everybody there in the taco shop. And
sure, easy to say that.
He was vilified by a lot of people.
Easy to say that when you're not the one sitting there in the taco shop, not knowing if you're going to be dead in a second because some crazy guy comes in sticking a gun in your face.
Yeah, you're talking about negligent discharge on the part of the shooter. What if the finger slipped of this crazy? What if he had a gun and his finger slipped and it shot somebody in the head accidentally? That can easily happen in scenarios like this. We don't know if the guy's on drugs. We don't know if he's mentally stable. So bottom line is the grand jury took a look at everything and they said, we think his conduct was reasonable. We are returning a no true bill. So we're really happy with the final result of this story.
Or they said, you know what? We don't care. This guy walked in there to rob the place. He got what he deserved, and we're not going to indict him, and that's the end of that. Okay, that's their right. They're the grand jury. Maybe a happy ending here. I think the moral of the story is if you don't want to be shot and killed, you can decrease your chances by not robbing places.
Yeah, that's a good point.
That's a good point.
All right, guys, leave us your comments down below. If you think we got something wrong, we'd love to interact with you guys in the comments. We'll answer all comments that are civil, and let's strike up a conversation about this. Do you think this case was decided correctly by the grand jury? And let us know your thoughts of our analysis. In the meantime, you guys can check out attorneysonretainer.us to learn more about our product and what it can do for you. This is a great program, and we are very, very proud of the program we've made. Once again, had this shooter in the taco shop been an Attorneys on Retainer client, we'd have been fighting each other of who's going to be at the initial appearance and who's going to show up to court, and we would have gladly defended this guy and busted out all the tricks in the toolbox.
I'm glad he didn't have to go through it, but man, that would have been a fun case to defend.
Absolutely would have sent a message too, but I hope that the message is loud and clear from this Harris County grand jury on what the standards are in this particular community.
This had a happy ending for the good guy, but it didn't have to be that way. So again, you got to really be more careful, I think, than this guy was. Remember, use the least amount of force that is reasonably necessary to stop the threat and no more. I think that's probably a good takeaway, even though this guy didn't get charged.
I agree with that. All right, everybody, this has been Attorney Andy Marcantel and Attorney Marc J. Victor. Peace.